hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, we shall be heard. God save these United States, great state of Florida, and His honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Welcome to this session of the Florida Supreme Court. Justice Polson is unable to be here today for oral argument, but he will be participating in the disposition of these cases. Our first case today is number 21-1047, State versus Manago. Whenever you're ready, counsel.
Thank you, Mr. Chief Justice, and may it please the Court. Christopher Baum for the State. Under Williams v. State, the 5th District erred in failing to consider whether sentencing respondent under Section 775.082 1B1 without the required jury finding constituted harmless error. This Court should quash the decision below and remand for the 5th District to consider that question in the first instance. And it should make clear that if the 5th District concludes that the error is harmful, then the remedy for that error should be either to remand for resentencing under Section 1B2 or to impanel or to allow the State to impanel a jury to make the required jury finding. Now, turning to the first question, appellate courts review judgments, not the reasoning of trial courts. And whether or not the trial court made a harmless error finding in its opinion, the underlying error in the judgment is the same. It's the absence of a required jury finding under Elaine. And this Court made clear in Williams v. State that that appellate courts are required to consider whether that error was harmless error under the harmless error statute. Now, because this Court is a court of review, not of first view, the Court should remand for the 5th District to consider in the first instance whether the error constituted harmless error. Turning to the remedy question, I think the Court should clarify that the remedy for a harmful error, a harmful Elaine error in this context, is either to remand for resentencing under 1B2 or to allow the State to impanel a jury to make
If we agree with
finding.
you as to the first issue, should we reach the second issue?
Your Honor, the second issue is important and recurring. As you know, it has come up several times, and this Court has been unable to address it. I think this case presents an opportunity for the Court to address it and to provide helpful guidance to the 5th District on remand. If it does conclude that the error is harmful, it would help to clarify and to resolve the important conflict in the districts on that question.
Can I ask you, maybe I missed it because I was trying to figure out if the clock was working or not.
Sure.
But what is your position, again, on trial courts performing or conducting harmless error analysis?
Well, I think this Court can provide clear guidance that if confronted with the same situation again, trial courts should either sentence the defendants under Section 1B2, which does not require the jury finding, or it should allow the State to impanel a jury to make the required jury finding.
I'm just having concern with the trial court in this particular case just conducting his own harmless error analysis and making a decision from that.
Yes, Your Honor. I think we're in agreement that the harmless error analysis is something that the district courts perform under the harmless error statute.
Right.
But under Williams v. State, the 5th District was required to perform that analysis, and in fact, it had no power to reverse the trial court's sentence under the harmless error statute without concluding that the error was harmful. And so that's why we think the court should quash the decision below.
Yeah, it's just having been a trial judge, I can see if we write an opinion saying, well, you trial court judges, you can go ahead and make a harmless error analysis, not just in this type of case, but other factual findings, other factual things. And I can see a situation where at the end of the trial, let's say the prosecutor gets up and says something, and let's pick something really outrageous that I would hope would never happen. But say something like, if a defendant is not guilty, why didn't he take the stand and testify and tell you that he's not guilty and tell you why? Obviously today that would be reversible error and probably a very strong opinion at least from me, and something like that. But I can see a situation where a trial judge would say, but you know what, this is closing argument, I already heard everything. We got videotape of a surveillance video of the defendant committing the crime. We have a confession from the defendant. We have DNA. He left his blood behind. We have fingerprints. We got people who identified him. So I'm going to make a harmless error analysis. I understand that that's wrong to do that, but a reasonable jury, rational, reasonable jury would convict this person and would not acquit just because that mistake was made by a prosecutor. See, I can see that kind of harmless error analysis all of a sudden being conducted. And that's the concern I have.
Sure, Your Honor. And I think in that instance, on appeal, a district court would certainly reverse in that instance. And so the harmless error analysis, whether or not the trial court performs that harmless error analysis, if the error below occurs, it's going to be subject to reversal if it constitutes harmful error in the district courts.
Well, I'm trying to avoid a case getting to us. We have enough to do.
Sure, Your Honor. But certainly the district courts could be able to clean that up.
So if I understand your position, you agree with Justice LaVarga that it was error for the trial court to conduct a harmless error analysis.
In this instance, I believe that you could call it error, but it is certainly not reversible error. And
but there's a lot of error that's not reversible error.
Absolutely, Your Honor. And
under Eileen, the trial court should have done one of the two things that you suggested, either impose a sentence under the new statute or impanel a jury, correct? That's your position.
That is, Your Honor. And it's also our position that the Fifth District erred in failing to consider whether the trial court's error.
So this would be like any other error under the statute, under the law. Our duty is to conduct a harmless error. The duty of the appellate court, the Fifth District, was to conduct a harmless error review to determine whether that error was harmless.
That's correct, Your Honor.
And they did that, or they didn't do that, so that's why we're here. And so I think Justice LaVarga's point is that maybe that just sort of seems unfair, that the error that the trial court had was to conduct a harmless error analysis, but then if the trial court was right, nothing happens. There's no relief for that error. And you admit that does sort of seem unfair, right?
Well, I think that on appeal, if the Court of Appeal thinks that there's no harmful error, then it doesn't have power to reverse that error. And whether or not the trial court provides analysis, the trial court could knowingly commit an error but not necessarily write that in the opinion, or it could conduct harmless error and say, well, I'm going to commit this error because I think it's harmless. Either way, the underlying error is the same, which is, in this case, you have a sentence that is unsupported by the required jury finding. And that is the error that the Fifth District was required to review for harmless error, and it failed to do so.
So far, sorry, go ahead. So far, we've been assuming that there is a harmless error analysis, that term means one analysis, but of course it doesn't. Can I hear the State's position on what the content of the harmless error analysis that should be applied by the court on remand, were we to remand with instruction to conduct it? Is it 924.33? Is it Williams? Are they different? What's the State's position on that?
I think it's Williams, and I think that it's whether a rational jury would conclude beyond a reasonable doubt that that respondent actually killed, attempted to kill, or intended to kill the victim in this case.
Whether a rational jury, any rational jury, it seems to me the case presents, if it presents anything, an opportunity to refine what the harmless error, what the content of the harmless error analysis is under Williams. And I'm wondering whether those two structures of it that I just outlined, a rational jury, any rational jury, are different from the state's perspective.
Well, I'm not sure that this case presents a great opportunity to resolve that particular question because, the parties have not briefed whether the standard is a rational jury, any rational jury, and I think that we're proceeding under this court's analysis in Williams and the test that it set forth in that case. And the state's position is that the Fifth District should have applied the test set forth in Williams, whereas respondent's position is that it was not required to do so. So I'm not sure that this case presents a great vehicle to address that question, Your Honor.
Are you familiar with the federal cases, I think at least in the Third Circuit, that analytically sort of first ask whether it's in these Alene cases, whether it's trial error or sentencing error, and when they decide that it's a sentencing error, they essentially don't look at the trial record, but they ask whether in the absence of the error, the same sentence would have been imposed. And so in this case, under that framework, if you deem this a sentencing error and you ask, without the court having, made this finding, could they have imposed the sentence? It seems like at least as to the review period, the 25 versus the 15, obviously that same sentence couldn't have been imposed. Is it possible that that's the right way to look at what the error was and how you apply harmless error that sort of gets at this issue of, I think it's weird to say that the circuit court didn't have the option of kind of looking at the record, that was kind of a wrong approach, but then for us to do a harmless error that looks at that as opposed to maybe looking at it analytically as just a sentencing error and then doing harmless error analysis on that.
I'm not familiar with those Third Circuit cases, Your Honor, but I think that the Williams approach makes sense in that you have a situation where you have an underlying Alene error and there's the required jury finding is missing, and I think the analysis is much the same as in many other harmless error contexts where the court simply asks, well, okay, looking at what the jury could have done, would a rational jury have found beyond a reasonable doubt that this defendant was the shooter or intended to shoot or attempted to shoot the victim. I think if you simply analyze whether the trial court could have imposed the sentence without the required jury finding, I think the inquiry collapses. As Your Honor mentioned, you would look at this case and say, well, of course, without the required jury finding, you can't sentence the defendant under 1B1. It has to be under 1B2. So I think that the court should make clear that trial courts have the option to either sentence a defendant without the required jury finding under 1B2 or to allow the state to impanel a jury to make the required jury finding. And that would be consistent with how this court has treated resentencing under Hearst and under subsection 10 of 775.082.
I mean, I guess the Hearst thing, though, there you at least have a statutory framework that assumes that there's going to be, in the death cases, that there's going to be a bifurcated, guilt phase and sentencing phase with fact finding. I mean, here we're kind of, it's no one's fault because you've got this confluence of, 3 separate lines of common law and then the new statute, and everybody's sort of trying to make the best of it. So on the front end, so going forward, is it fair to say that the right way to do this in a new case where it happens after the 2014 statute went into effect, that the jury that the question needs to be posed to the jury, and if that doesn't happen, could you reconvene a jury or have that same jury then in the sentencing phase do fact finding in that situation too?
I think that would present a slightly different question, and As you explained, there's the statutory framework in the Hearst context, but as this court explained in Game On, in the subsection 10 context, there was no statutory framework to necessarily address this issue, but the court has inherent authority to do so when the legislature has not yet had a chance to address the problem. And so, of course, going forward, if we're talking about a defendant who, well after the events and well past the procedural posture of this case, that the question was, well, they were inappropriate. The jury was not properly instructed, even though everyone agrees that they should have been instructed to make this finding. I think that's a much different question than what we have here, where we're simply trying to fix the problem that arose given the lines of cases that Your Honor is talking about.
Counsel?
There was, go ahead.
I would have just asked something you just said about our inherent authority to fix. How far does that go? Where is the line in which we can fix a statute that has constitutional issues? In Game On, the court at that point said, we feel like we can do that in this case. But there's definitely nothing in the legislative scheme that contemplated impaneling a jury years later. The legislature's always thinking about judicial resources. There's debate. There's policy considerations in a legislative scheme, none of which we are meant to address. So where is the line in our inherent authority that you speak of that would allow us to fix the statute or not? What is our kind of mark there?
Well, I don't think you would be crossing over the line in any event if you were simply to say that the remedy in this case is the same as it is in the subsection 10 context. We're talking about the same statute. We're talking about the same remedy of impaneling a jury to make the required jury finding. And that's consistent with how the court treats these errors in the Hearst context. Because even in the Hearst context, the bifurcated proceedings are not contemplated to fix this type of sentencing error. They're contemplated to ensure that the penalty phase and the guilt phase are distinct. And yet this court allows the use of impaneling a jury on remand for resentencing, because resentencing is de novo. And so I think it would be consistent with Game On. It would be consistent with Hearst. It would be consistent, and it would treat Elaine errors across the board consistently, where you have the absence of this finding. That trial court should have the option to impanel a jury if the state so chooses.
And in this particular case, where the state never even hinted at asking the court to have a jury come in, I mean, should that affect? I mean, I understand people would systemically, it might be good to have some certainty as to what the court thinks as to what are the available remedies. It seems odd in this particular case to have that be the remedy.
Well, Your Honor, I don't think that there's any question of preservation, because it would have been futile for the state to have requested either in the trial court or in the district court to allow the state to impanel a jury, because under Williams and Williams's remedy holding, that wouldn't have been an option. And the state is not required to preserve a futile or make futile attempts to preserve remedy requests. So I don't think it would be.
Your position here, what you're asking us to do is to remand the case back and panel a jury and make this decision.
No, Your Honor. Just to clarify, the state is requesting that the court quash the 5th District's decision below and remand for the 5th District to consider whether the error in this case was harmless in the first instance. Now, if the 5th District concludes on remand that the error was harmful, then we're asking that the court clarify that in that circumstance, the 5th District can remand to the trial court either to resentence respondent under 1B2 or to allow the state to choose whether to impanel a jury to make the required jury finding.
Counsel, you're into your rebuttal time.
Thank you, Your Honor.
Good morning, Your Honors. Matthew McLean on behalf of the defendant, Herbert Leon Manago, who's the appellee in this case. I'd like to begin by addressing the error that was committed in this case by the trial court. At the time of the resentencing, the trial court was armed with the decision of Williams. It recognized Williams required a jury finding as to whether the defendant actually killed, intended to kill, or attempted to kill the victim in the case. Knowing that, it proceeded to go ahead and commit an error because it deemed the error would be harmless. A court is supposed to faithfully apply the law, not commit error knowingly and because it believes the error to be harmless.
The verdict form that was provided to the jury did not provide, did it, for the jury to make a determination that the defendant was the shooter?
It did not. It had no special jury findings. So the jury verdict form was for felony, first-degree murder, and carjacking with a firearm, but no special verdict findings were requested.
Why is that? I mean, I don't understand why that wasn't provided to the jury.
I believe it was the state's position that they didn't need to prove it to get the conviction. To get felony first-degree murder, they said, look, we believe that he was the shooter in the case, but we don't have to prove it. He could be a principal in the situation. So because we don't have to prove it, don't decide it. Just find him guilty of felony murder and armed carjacking with a firearm.
So under that theory, any of the three could have been charged with being the shooter.
Correct. And if you look at the
sentence as the shooter, I mean.
If you look at the indictment in the case, the state charges him as if he was the killer in the case, but then it alternatively charges him as if he was participating and helping the co-defendants who might have been responsible for the actual killing in the case. So the state proceeded under dual theories below. So the state's taken the position that the harmless error analysis was not conducted by the Fifth District Court of Appeal. The Fifth District went ahead and clarified its position, saying it did conduct a harmless error analysis. While it's not the one in Williams, it's an analysis of, I think, more of a practical approach. What would have happened correctly under the situation? If the court would have found that there was no jury verdicts to support the enhanced sentencing, they would have sentenced Mr. Manago pursuant to 1B2.
Are you asking us to overrule Williams?
No, I'm not asking you to overrule Williams.
So then what's the justification for the departure from Williams?
I believe it's the error that's committed. I believe that cases decided prior to Williams did not know that they were knowingly committing error. It's only after Williams came out which a court then becomes aware of the law. And if they recognize the law and go ahead and commit an error knowingly just because they conducted an harmless error analysis, that's the problem that is trying to be avoided. So there's no reason to overrule Williams. The practical approach going forward is courts, and there's no verdict to support an increased sentence, then they should go ahead and impose a sentence that complies with the verdict form.
I mean, subsection 2.
Correct, under subsection 2, and that's practically what should have happened in this situation post-Williams.
In terms of appellate standards, what you're arguing for is a per se reversal rule under these circumstances. Is that correct?
Under this situation, it would.
For Eileen error that's committed because a trial judge performs the harmless error analysis that they're not supposed to perform, you would say it's a per se reversal rule is appropriate in those instances.
Correct. If recognizing that it is the law, then it would be per se not to follow the law. Essentially, you would be encouraging courts to go ahead and commit an error with the hope that later on the appellate court's going to go ahead and find the error to be harmless, and that's something that should be discouraged, not encouraged.
How do you square that with the statutory directive that appellate courts not reverse except for harmful error? And within the context of we know what harmful error is, that's error that would have made a difference. And I heard your earlier argument, but please address that.
So I guess I would stick with my position before, is that the harm isn't what the result would have been. It would have been a different sentence under 1B2 compared to 1B1. And that's where the error is harmful in this situation. But even if this court were to apply the Williams rule harmless error analysis, there's no reason why this court couldn't decide whether the error was harmful. In Williams, in announcing the rule, this court actually conducted a harmless error analysis and found that the error was harmful. So there's no reason to have the court go back to the District Court of Appeal when this court is able and has done so in the past in conducting its own harmless error analysis. Believe that the error is harmful in this case. It falls in line with the cases where there's multiple defendants who were charged with the crime. There's multiple theories presented as to who the killer was, and there's no clear verdict finding as to what the jury actually decided.
Doesn't the statute sort of whoever wrote this statute thought that there was going to be a judicial finding on affirmatively whether the person, met any of these criteria. I mean, if you read the statute literally, it's not really, in the absence of a finding that they were the shooter, it doesn't really allow you to apply to, because it says a person who didn't actually kill, intend to kill, or attempt to kill. In this case, we don't have any jury finding that he wasn't the shooter. So should that factor into, should we, given sort of what the requirements of the statute actually are, doesn't that kind of lead us to, to say that the only right thing to do here is, in every one of these cases where we're trying to retroactively apply the statute, that we do need to have a jury come in and kind of decide one way or the other which box they fit into, which box the defendant fits into?
So are you talking about the remedy, assuming that there would be
Well, I'm
an error?
talking about how to comply with, because there's kind of an assumption that you quote unquote, comply with the statute by assuming that the person wasn't the shooter just because of the absence of a finding. But the statute isn't really, it's not written that way. The logic of the statute is that at the time of sentencing, you're going to know which box to put the person in. And the absence of a finding doesn't allow you to put them in the B2 box. It just means that you can't necessarily put them in the B1 box.
I agree. I think the statute is written so when you come to sentencing, you're going to know whether the defendant falls under B1 or B2. And that's unlike subsection 10 in the statute, which is more of a sentencing consideration. It says that, and I think that's the reason why in Gaiman this court crafted the remedy it did, is because the legislature intended post-verdict for a judge to decide whether a non-state prison would be dangerous to the public. In the situation of 1B1, it's contemplated, and going forward in the standard jury instructions, that the jury is going to be instructed as a matter of first impression in reaching the verdict of whether this person actually killed, intended to kill, or attempted to kill the victim. And the same goes with the death penalty context. It's contemplated by statute that there's going to be a guilt phase and a penalty phase, and these penalty phase sentencing factors are going to go ahead and be considered post-guilt verdicts. So coming back to, what ultimately the remedy is going to be in this case, we understand it's a unique set of circumstances that, this is a law that's being applied retroactively, and the parties were not in a position of knowing that at the time. But that doesn't go ahead and throw out all the other law that's in place as to what should happen in the case.
And you don't have any case standing for the idea that a reviewing court applies harmless error differently depending on whether the judge, depending on the clarity of the law that the judge was departing from below. Because the logic of your position is that after Williams, if a court, in Williams, the trial court had done the fact finding, I guess, in some kind of, new hearing. And yet we said that there needed to be harmless error analysis there. The logic of your position seems to be that if a judge today held a hearing that that the reviewing court then couldn't do harmless error review because it would have been such a clear error that it was intentional. Isn't that what you're saying?
Yes.
And there's no, you don't have any case law support for harmless error being applied differently depending on whether the judge knew what the judge was doing was error.
Not in this exact context, but I think if that were to be the approach taken, then a lien apprendi errors would have no real meaning to it, because the appellate court would just simply, or the trial court would simply say, I'm going to impose the increased sentence because I'm able to, even though I know I'm committing error, because ultimately it's going to be harmless. So if you don't find that to be error, then it's going to be encouraging courts to not follow the law faithfully. And so it's a unique set of circumstances, and I think that going forward, everyone would agree that
but you could make the same point about a harmless error analysis in any case. That the fact that that is there is an incentive for for errors to occur if a judge thinks it really doesn't make any difference, and it's not going to make any difference at the end of the day. I mean, it seems like I don't understand the limiting principle that that you really can rely on. I mean, I understand. I mean, I agree with you. The judge should not have done this. The trial judge should not have done this. But I'm struggling to find some kind of limiting principle that would not really basically undermine the whole harmless error enterprise. Now, I know some people think we shouldn't have harmless error analysis, but we do. And so, what am I missing there?
I think the key part that's missing is the knowing part, knowingly committing error in the situation. In this case, we're fortunate enough to know that the court recognized in his order that he was committing error, but conducting a harmless error analysis. So if you have
but there are some errors that trial courts make that are pretty clear. Is it every time that there's law that shows that, I mean, we presume judges know the law. Every time a judge makes an error where the law is clearly established, that we would presume the judge is on notice of the law, that we presume that that's intentional.
I guess I'll put it in an example. Say there's a hearsay objection, and it's clear that it's hearsay, and the court says, you know what, I'm going to go ahead and allow that hearsay to be admitted because I know in the end of the day it doesn't really matter. It's going to be harmless. You know, in that situation, you're having courts make decisions based off. So is it more like
your theory is more like loose lips sink ships. The judge might think that and act accordingly, but if he articulates that, then we're in a different territory.
I think if he articulates an harmless error analysis on the record, then the judge should be reversed in that situation. Going to the remedy in this case that the state's asking for to impanel a jury, I'd like to first start off with preservation. Trial court silent as to requesting to impanel a jury. Briefing at the 5th District Court of Appeal, silent as to requesting the ability to impanel a jury.
But so this was going on after Williams, right?
Correct.
Well, wouldn't all that been futile?
I don't think it would have been futile. You would have preserved your argument. If you want to overturn something, you present the argument knowing, and you cite to the case law, we understand that Williams is the law. However, we think it's wrongly decided for these reasons, and you present and preserve the argument.
Do we require that?
I think that you have to fairly present the argument to the court.
To a court that can't act on it? Do we require that? Do we have cases that require that?
I think certainly maybe not at the trial court level, but the appellate court level, and where the state goes even further in this situation, at oral argument, when they're confronted with, well, what is the remedy that you're asking for? Do you want to have a jury impaneled in light of the Green decision? Since now
do you have a case where we have required that in circumstances like this, where we have a binding precedent, a precedent that binds the trial court and the district court, where we require that an argument be made for the overturning of that precedent in the trial court and the district court? On
hand, I do not, Your Honor.
Pardon?
On hand, I do not have a case that says that. But I would like to point out that when confronted by the 5th District Court of Appeal, they said, look, I don't even know. I doubt that we would impanel a jury 15 years later after the fact. So when given the opportunity to post-Green, when there's now a conflict between Williams and Green, to seek that remedy, that the state said, you know, we don't even think it would be something that we would do.
Assuming we don't agree with your preservation argument, what else you got on this?
Stare decisis. This court went ahead and decided Williams 4 years ago. It confronted the exact issue that is being presented here as far as the remedy to impanel a jury. And they're asking this court to overrule the precedent when really there's been no reason to go ahead and do so. The decision has proven workable. It would lead to an injustice of Mr. Manago being treated differently than other defendants like situated. And there's been no factual circumstances that would justify departure from this court's precedent.
So your position here today then is that it wasn't proven during the trial? The jury didn't make the finding, that is, And therefore, we should remand it and instruct the trial court to sentence Mr. Manago pursuant to subsection 2.
Correct, just as it did in Williams.
That's what we did in Williams.
Correct. There's no reason to do so. And in the briefing, the state hasn't provided a single case that approves the practice it's requesting under these circumstances. The only case law that's out there at this time is saying you shouldn't do it. This court did it in Williams. This court cites a Pena from the First Circuit Court of Appeal. I provided this court with case law from the Pennsylvania Supreme Court, which, like this state, has capital sentencing proceedings and bifurcated sentencing proceedings. And the Pennsylvania Supreme Court, in the same situation, said, look, we're not going to legislate from the bench. If the legislature wants to come up with a mechanism to impanel a jury post verdict, let them go ahead and do that, but we're not going to touch it. So every jurisdiction that I'm aware of, when presented with similar situation, has not gone the direction the state wants its court to go. And when you even look at the United States Supreme Court in Alene, their remand instructions was send it back for resentencing consistent with the verdicts in the case. That's what we're asking for this court to do.
I'm going to read from Statement v. DeGaio. Per se reversible errors are limited to those errors which are so basic to a fair trial that their infraction can never be treated as harmless. And then from Chapman versus California U.S. Supreme Court, when involving constitutional violations, such errors are always harmful. Now, and the idea is like if a defendant is completely deprived of counsel at trial, that's a constitutional violation, it's a structural violation. And so as I understand your argument, because this is a constitutional violation, the right to have an issue decided by a jury, it's structural, and it's the kind of error that needs to be treated as per se reversible in order to get the relief that the Constitution warrants. That's your argument?
I believe that's a good way of summing it up.
And then how does that square with Williams? If we accepted your argument, how could we maintain the Williams harmless error directive for appellate courts to do in these circumstances?
So we're going back to whether error was committed in the case?
No, I mean, Williams says that the appellate courts to conduct a harmless error analysis in this circumstance where
I think the error occurred, one step before reaching Williams. It's a different type of error as recognized by the 5th District. So it's not a Williams error per se. It happened before it got there. So that's the best argument I have for that. But even going back to if the court says, look, you still have to conduct a harmless error analysis in this case, there's no reason to find that the error would be harmless in this situation. And I would add to not only the circumstances of the trial in this case, but talk about due process consideration. If there's going to be such an important finding that's going to change someone's sentence between a mandatory 40-year sentence and a 15 versus 25-year review, shouldn't that defendant be put on notice of that requirement and be able to present evidence, an argument to a jury to make that finding? To go ahead and just say things would have been the same and let's conduct a harmless error analysis based off what was put forward to that trial when now the rules of the game have changed, that would be a due process violation in our perspective. See that I'm running out of time. So in sum, I'd like to ask this court to affirm the remedy provided for in Williams. I'd like for the court to affirm the 5th District Court's finding of error in the case and to remand for Mr. Manago to be resentenced pursuant to 1B2. Thank you.
Counsel, can I ask you a question? So it seems, the fact that the state here didn't ask for a jury to be brought in and, lots of time has gone by, it seems like in a lot of cases there are going to be serious practical problems, even if it's a legally available option. And it seems like under a lien, it's not a constitutional option for the judge, him or herself, to have a fact-finding hearing where the judge makes the determination. Is it the state's position that it's not, if we're thinking about, what should the rules be going forward in these cases where we're applying the statute retroactively, is it the state's position that it's not a constitutional option to essentially tell trial courts that they can, they're bound by whatever happened at trial, there's no kind of new fact-finding, but that they can sort of look at that record and decide whether any rational jury presented with this information would have found beyond a reasonable doubt that the person was the killer or met whatever the B1 criteria are? Is that off the table?
I think that option's off the table because I think it's the same as the judge making the finding.
It's not. I mean, it's not really the same thing. I mean, it's you're not. It's not the judge kind of affirmatively finding
Sure.
as a fact. I mean, it's you're limited to what happened before, and it kind of gets back to this question of, if we sort of reinvent things, was the error the failure to not have it, during the trial? We all know that the reason why it wasn't done is because the law changed.
Sure.
But if you sort of reconstruct the error as the failure to have had it there, then, there is a real difference between sort of confining yourself to that. The state doesn't get to do anything new. The judge isn't sort of exercising their own kind of sense of, of what the fact is. They're just looking at that. But your position is that that's not constitutionally an option.
I think that's right because on appeal, again, the District Court of Appeal is reviewing the judgment, not the reasoning of the trial court. And so, whether the trial court said I can sentence under 1B1 because I'm making the finding, or whether I can sentence under 1B1 because I think doing so would be harmless error, either way, the error underlying the judgment is the same. And so the question for the district court is whether that error was nevertheless harmless under Williams. And just a couple of other quick points. The reason why the jury form did not require the finding here was because this occurred pre-Elaine, and so there was no reason for the trial court to have included that in the jury form. I think Your Honor formulated
You're saying it wasn't a purposeful choice by the state to proceed in the alternative in the way your opponent suggests.
Well, it was a choice to proceed both on the principal theory and on the first degree theory, yes. But as for the jury finding, that was pre-Elaine.
Well, it wasn't just pre-Elaine, it was pre-2014. I mean,
Yes.
It's the statute that made this.
Yes, that's right, Your Honor. That's right. And I think Your Honor formulated the per se reversible harmless error theory perfectly in that it's loose lips sink ships. If the trial court is considering, an objection to the introduction of testimony that's, nobody is really going to care about this after the trial, and the trial court thinks, well, I think it would probably be upheld as harmless error so I'm overruling the objection. Nobody would think that objection would not be subject to harmless error on appeal. But then if the trial court goes ahead and says, I think this will be harmless error, and overrules the objection that is somehow per se reversible, I don't think that there's anything in this court's case law that supports that theory.
Counsel, I have a question about the preservation
Sure.
issue quickly. You argued here in your brief that Gaimon essentially sort of undercut everything Williams stood for as far as the impaneling a jury. I think, is that a fair reading of what you're arguing?
Yes, Your Honor.
Did you argue that at the Fifth?
No, Your Honor, but the case law that provides that we do not have to make such futile arguments is cited in our reply brief.
It's not really a futile argument if you're arguing that there is no precedent then. I mean, you're arguing they've already changed their minds at the Supreme Court Fifth, and you can follow Gaimon now.
Well, I think to be clear, to clarify my previous answer, I think that the district courts could not have extended Gaimon into the Williams context because Williams still remains good law until this court recedes from it. And I see that my time is up unless the court has any further questions.
You want us to include loose lips sink ship in our opinion?
If at all possible, Your Honor. Thank you.